I'm going to send a question to you for answer in writing, so I can ask Judge Jackson only one question. You've worked on sentencing reform, and as someone who has worked hard on the First Step Act and other issues of criminal justice reform, I really appreciate your work on the sentencing reform. Now, when it comes to more sentencing reform, people like you and Judge Bill Pryor both agree sentencing needs to be reformed. Can you explain how your views differ from Judge Pryor's, or specifically, why do you trust judges with more discretion when it comes to sentencing than Pryor does?
Thank you for that question, Senator. And first, let me just say, as a former member of the Sentencing Commission, thank you for your work. I know that the chairman, that Senator Lee, and others on this committee were very, very active in making changes to the sentencing system, partly because the commission did research and pointed out to you some of the disparities in our laws, and Congress has made changes that have been very beneficial to the system. I did have the privilege of serving with Judge Pryor. We were on the commission together, and he and I both did talk quite a bit about, in our public statements and in the meetings, about the need for reform and how do we change the system after the Supreme Court's decision making the guidelines advisory and not binding anymore on judges. I would say my primary answer is because, in my experience, most judges really don't like to be outliers when they're sentencing. Most judges really do want to do something that is consistent, not only with the law, but also with what similarly situated other defendants are getting in their district. So in my view, instead of more mandatory minimums or prescriptions that actually bind judicial discretion, if we could just give judges more information, that turning to a repository of information like the Sentencing Commission that captures every sentence that federal judges give, and then giving judges access to that information is a way of ensuring that judges are handing out fair sentences that are similarly situated to other defendants. I think Judge Pryor he said that we need to do a little bit more to constrain judicial discretion, but my hope and faith is that judges will constrain themselves to an extent when they get the information that they need.
Senator Cornyn, I'm sorry.
Thank you, Mr. Chairman. Let me say to both of the nominees, I very much appreciate the fact that both of you have had extensive trial court experience as practitioners and as a judge in the case of Ms. Jackson. I think that's a very important qualification for somebody who's going to sit in judgment on an appellate court, that they actually know how the trial courts operate and understand the appropriate standards of review on appeal. Both of you have a very impressive background. I agree with my colleagues that it's important to have, for the public, have confidence in the judiciary. And I think part of that confidence is knowing that people like them can serve on the bench, and that we applaud that diversity. I've noticed a difference in the way those issues have been treated in the past when my Democratic colleagues blocked, for example, Janice Rogers Brown, an African-American on the D.C. Circuit, Miguel Estrada. Thankfully, we've had some great judges in the Western District and Northern District of Texas, people like Ada Brown and Jason Pulliam in San Antonio, and then Asian American Circuit Court Judge Jim Ho, who was confirmed for the Fifth Circuit. But since our Democratic colleagues seem to be placing so much emphasis on race, and I just want to ask this question. none of us can choose our parents. And even if we could choose our parents, I suspect that most of us would choose the very parents we have. But what role does race play, Judge Jackson, in the kind of judge that you have been and the kind of judge you will be?
Thank you, Senator. I don't think that race plays a role in the kind of judge that I have been and that I would be in the way that you ask that question. As I mentioned to Senator Feinstein, I'm doing a certain thing when I get my cases. I'm looking at the arguments, the facts, and the law. I'm methodically and intentionally setting aside personal views, any other inappropriate considerations, and I would think that race would be the kind of thing that would be inappropriate to inject in my evaluation of a case. I would say that my different professional background than many of the Court of Appeals judges, including my district court background, which will be different if I'm confirmed than many of my colleagues, would bring value. It's sort of like the Oliver Wendell Holmes quote that the life of the law is not logic, it's experience. And so I've experienced life in perhaps a different way than some of my colleagues because of who I am. And that might be valuable. I hope it would be valuable if I was confirmed to the court, the circuit court.
Thank you very much.
Confirmed. I'm going to dive right in. I've got a number of questions. We'll start with you, Ms. Kumi Jackson. It's been widely reported that President Biden met with you in anticipation of your nomination to the U.S. Court of Appeals for the Seventh Circuit, and congratulations again on that nomination. During that meeting with him, were you asked for commitments regarding, or did you discuss abortion or Roe versus Wade, Second Amendment, or D.C. versus Heller, efforts to defund the police, illegal immigration, any of those issues?
None of the above, Senator.
Okay. Judge Jackson, what about you?
No, sir.
Okay. Judge Jackson, in your notes for a presentation that you gave at Columbia Law School in 2019, I believe, you said that, quote, disparities in judicial outcomes can also occur when judges consider legitimate and relevant factors, close quote. Talk to me a little bit about what that meant.
Thank you, Senator. That presentation was a symposium that I'd been invited to comment on an article that was being presented. And the article itself was about judicial bias. And I was critiquing it and making arguments in response to it based on my experience. And I believe that I would have to see exactly the context of the quote that you read, but what I was suggesting was the idea that because the factors in the law concerning something like sentencing are open-ended, that Congress says you have to sentence defendants to terms of imprisonment that are sufficient but not greater than necessary to promote the purposes of punishment. And it lists the purposes of punishment. And any judge who looks at that has basically those broad parameters within which to think about how they're going to sentence. But the judge then will have to decide whether they're thinking about deterrence or retribution or various purposes in order to determine how they're going to sentence. And my idea was that a similarly situated judge looking at the exact same set of facts, applying those factors in 3553A, could reach a different result. So that you're going to have sort of inherent in the nature of judicial exercise of discretion in the world of something like sentencing, disparity, unbeknownst.
No, that's helpful.
Yes.
Now, I believe you've been a judge now for about 8 years, if I'm not mistaken. In your experience as a judge, and prior to that, your experience as a lawyer, Would you agree or disagree with someone who said that most racial disparities in criminal convictions and sentencings result from an unconscious racial bias of judges, juries, and other judicial decision makers? Would you agree or disagree with that statement?
Well, Senator, let me just say that as a judge now, it's very important for me not to make, personal commitments about things like the question that you asked, that my personal views about anything don't impact my rulings. I am aware of social science research. There is a professor at Harvard, Professor Banaji, who has done implicit bias work. And there are studies from the commission when I was back at the commission in the policymaking role that talked about and indicated that all of us, human beings, can have biases that we are unconsciously operating on, and that we have to think about that when we are making decisions, and especially policymakers in the criminal justice system.
No,
I'm aware of those studies, but I'm not a social scientist, so
No, I understand that. And I'm just asking for your overall sense as a judge, and certainly not for a commitment or social science. In 2019, I think in connection with with notes prepared in connection with the same speech, you noted that, quote, observed inconsistencies are largely attributable to factors other than group-based bias by judicial decision makers. Does that ring a bell? Is that something you
yes, in the
stand by?
context of the critique that I was making, because the article had indicated that they saw, they showed research that there were these demographic disparities, and the article said that they were attributable to bias.
Right.
And so I was trying to give another perspective.
Right. So what are some of the leading factors that is other than unconscious bias that you see having an impact there, that account for some of the disparities that we see in convictions and in sentencing?
Well, one of the things that I was aware of in my time on the Sentencing Commission, and is something that you all have worked on, were the differences in statutory penalties for things like crack and powder, that many
Vast disparities between what you get sentenced for with crack versus
correct,
powder cocaine.
and that it was having a demographic effect, because the research and statistics showed that an overwhelming number of defendants who were convicted of crimes involving crack were African American.
Thank you, and that is very helpful. I do want to make sure I get to one other thing I wanted to talk to you about before I run out of time. You've remarked that presidents are not kings. That's a comment that I've made a number of times as well, and tend to agree with it. Whenever you're sitting in any court, from time to time you have to review executive actions. It seems like executive actions have more of a likelihood of coming up in the U.S. Court of Appeals for the D.C. Circuit than many other places. You think it would be appropriate, under the guise of prosecutorial discretion, for any president of the United States to tell an agency not to enforce a particular law?
Senator, I'm unfortunately not going to be able to engage in a hypothetical discussion, precisely because those kinds of matters might come before me, and I don't want to prejudge any case that might involve those facts.
Okay.
I do understand the implications of the law related to it, but I can't tell you whether it would be appropriate or not.
Okay. I'd love to delve more into this. I see my
Congratulations to you both on your nomination. Is it Judge Brown Jackson or Judge Jackson?
Jackson, please, thank you.
Judge Jackson. In your career before you were a judge, have you ever represented a terrorist at Guantanamo Bay?
About 16 years ago, when I was a federal public defender.
Okay, and was that case assigned to you as a federal public defender?
It was?
Who was the client that you had?
Oh, Senator, I don't remember the name.
Okay, could we get that for the record, please?
Sure.
Thank you. Ms. Jackson Akumi?
Jackson Akumi.
Akumi.
Thank you.
I want to make sure I get it right. In your legal career, have you ever represented a terrorist at Guantanamo Bay?
No, Senator.
Thank you. I want to speak about race discrimination in the Constitution. Ms. Jackson Akumi, does the Constitution allow the government to treat Americans differently because of their race?
No, Senator.
Thank you. I'm glad that we agree on that. Judge Jackson, did I get your hand?
No, Senator.
Thank you. Let's turn to religious liberty, if we can. The First Amendment protects the freedom of religion. This also means the government can't institute blanket policies that treat religious organizations, such as churches, worse than they treat secular organizations, such as restaurants or clubs or casinos. Is that right, Ms. Jackson-Akumi?
Senator, the First Amendment protects religious liberty, religious freedom, exercise of religion, and all of those issues are being actively litigated right now, including at the Supreme Court.
But the government can't treat a religious organization worse than they would a secular business, like a restaurant or a casino. Is that correct?
Senator, you're referring to the principle about neutral laws, and there is a principle there that if a law is neutral as to everyone, a religious organization can be included. And it's my view that the Supreme Court is testing the areas of that. For example, the Supreme Court recently granted an injunction out of California that involved one of those issues. So I just wanted to be sure to reflect the nuance there, Senator, and the fact that the Supreme Court is working through those issues. And I'll also add that First Amendment litigation has not been my area of practice the last 10 years or even 16 years. But that's my broad understanding of what's happening with the clause right now at the Supreme Court.
Thank you. Judge Jackson?
Yes, Senator. I, too, have not had many cases involving religious liberty issues. I have one right now that might involve some of these issues, but I am aware that the Supreme Court has rightly viewed the First Amendment right to religious liberty as foundational, fundamental. It's in the First Amendment, and the Supreme Court is working through the doctrine. There's been a series of cases in the last few years as the court determines what it means to treat religious organizations differently.
Thank you. Let's turn to the Second Amendment, Ms. Jackson-Akumi. Do you believe the Second Amendment protects an individual's right to keep and bear arms for self-defense?
Senator, the Supreme Court has said that very clearly. That was Justice Scalia writing in Heller, that the Supreme Court protects an individual right to keep and bear arms.
Which has been extended to the state and local governments through McDonald, correct?
That's correct, Senator.
Okay, what do you believe are the limits on that right?
Well, that's the very thing that circuit courts across this country and the Supreme Court are figuring out right now.
Do you have any personal views on that?
Well, if I had any personal views, they certainly wouldn't be relevant to decision-making that I would engage in as a circuit judge. If confirmed, I would be bound by the Supreme Court's precedent in Heller, in McDonald, and any of its progeny that develops.
Okay. Judge Jackson?
I agree wholeheartedly with what Ms. Jackson-Akumi said. Any personal views regarding the fundamental right to bear arms would have no bearing on my decision-making concerning those issues, and I would be bound by the Supreme Court's and the D.C. Circuit's precedents concerning the issue.
In Heller and McDonald?
In Heller, McDonald.
Thank you. Ms. Jackson-Akumi, do you agree with Justice Stephen Breyer and the late Justice Ginsburg that the Supreme Court should have 9 justices and justices should not be added?
Well, Senator, I will have to admit that I'm not familiar with their particular views on that issue, and I don't think it would be appropriate, as I indicated in a question from your colleague, for me to opine upon the composition of the Supreme Court or what should or shouldn't happen. It is a question that this body must sort through. It's a question left to the legislative branch and the executive branch.
Yes, Senator, I'm currently...
I won't even ask since you're sitting.
Okay, thank you.
All right. Thank you both for your testimony today, and congratulations again.
Thank you.
Thank you, Senator Cotton. Senator Coons.
Thank you, Chairman Durbin, and welcome to our 2 nominees who are before this committee today. Both of the nominees before us are highly qualified and impressive candidates, and both have demonstrated a commitment to justice.
My final moments, I wanted to say, Judge Jackson, that I noticed, I think I'm right about this, that you served some years ago on the board of Montrose Christian School. Is that right? Have I got that right?
Yes, Senator, for about a year.
Got it. Well, I mention it because I noted in the board's statement of faith at the time, it said that we should speak on behalf of the unborn and contend for the sanctity of all human life from conception to natural death. It went on to say that children from the moment of conception are a blessing and heritage from the Lord. The school also took the position that marriage is the uniting of one man and one woman in a covenant commitment for a lifetime, and that the state has no right to impose penalties for religious opinions of any kind. Now, those are positions that I happen to agree with, which is beside the point. I raised them because I distinctly recall that Justice Amy Barrett was attacked for serving on the board of Trinity Schools, which took similar positions. I defended her at that time. I'd certainly defend your right to religious liberty and to serve on this board, whatever your opinions may be, at the same time. And I take it that from your service that you believe in the principle and the constitutional right of religious liberty. Is that fair to say?
Well, Senator, I do believe in religious liberty. That is a foundational tenet of our entire government, our constitutional scheme. The Supreme Court has made clear through its case law that governments can't infringe on people's religious rights. Those ideas, that concept comes from my duty to observe Supreme Court precedent, to follow its tenets, not from any personal views that I might have. And any personal views about religion would never come into my service as a judge. I would also say that I've served on many boards and that I don't necessarily agree with all of the statements of all of the things that those boards might have in their materials. The statement that you read, I'm not even sure that that was something that was in the school's circumstances at the time that I was there, because I was not aware of that. But in any event, I do believe in religious liberty, yes, Senator.
Thank you very much. Thank you, Mr. Chairman.
Senator Blumenthal,
Chairman.
please proceed.
Thank you, Mr. Chairman. To Judge Jackson and Ms. Jackson-Okume, congratulations on your nomination. I'm sure your family and your friends are very proud of you, and rightfully so. But Mr. Chairman, I think it's important to highlight one of the key reasons why we have these nominees before us today. The group Demand Justice, a group I've spoken about in this committee before, and I spoke about it when Senator Whitehouse held a hearing on the issue of dark money campaigns behind judicial nominations. That group is largely responsible for the nominations that we have before us today. Demand Justice is a dark money liberal group whose first priority is getting left-wing judges who will follow a liberal agenda instead of the Constitution, if confirmed. I should also add Demand Justice is spending millions of dollars advocating for the expansion and the packing of the Supreme Court. In fact, they've been pushing for liberal judges since before President Biden was even elected. Like many of us last year, Demand Justice called on candidate Biden to release a potential list of Supreme Court nominees, but he refused. However, Demand Justice released a list of their preferred Supreme Court nominees. The short list was first released in October of 15, 2019. And without objection, Mr. Chairman, I'd like to submit two documents that were on the Demand Justice website for the first and the second list that I'll talk about in a moment. The first list contained 32 names of bold progressive leaders who would help rebalance the Supreme Court. According to Demand Justice, their list included lawyers who have championed progressive values as public defenders, public interest lawyers, scholars, plaintiffs' lawyers, and elected officials. However, the two nominees before us today were not on the first Demand Justice list. But in April of 2020, Demand Justice released a second short list of their Supreme Court nominees for soon-to-be President Biden to pick from. Both Judge Jackson and Ms. Jackson Akumi were on this list, on the second list from the Demand Justice. And now they're sitting in front of this committee today as nominees to circuit court positions. So what changed between the first Demand Justice list and the second one? In Judge Jackson's case, roughly 1 month after the first Demand Justice Supreme Court short list came in, Ms. Jackson, Judge Jackson, issued a ruling in a case brought by House Democrats who wanted to compel former White House counsel Don McGahn to testify. While we can debate the conclusions of Judge Jackson that Judge Jackson made, one thing is clear. The 120-page ruling had a purpose. I think Rachel Maddow explained the purpose of the 120-page ruling well. If the production crew can run the video clip of Ms. Maddow, do so now.
The judge in this case, Judge Ketanji Brown Jackson, tonight has ruled against the president and has ruled that in this specific instance, the official that the president has instructed to defy the subpoena, former White House counsel Don McGahn, the judge says Don McGahn must comply with that subpoena and he must turn up to Congress to testify. And this is a long ruling tonight. But it's interesting. It seems to me like it is written with a broad audience in mind, because it's not a super legalistic thing. It's not just a mechanistic order that McGahn has to show up and here's the precedents that lead to that and so forth. This is the kind of court order, the kind of judicial ruling that is, if this were an indictment, you'd call it a speaking indictment, right? This is a ruling that is designed to be read by people who are outside this case.
So just to repeat some of the comments, the ruling was written with a broad audience in mind. It's not just a legalistic thing, kind of a judicial ruling, that is. If this were an indictment, it would be a speaking indictment. This is a ruling designed to be read by people outside of the case. This case was 1 month after Demand Justice Supreme Court shortlist came out. The Demand Justice released their second Supreme Court shortlist in 2020, and Judge Jackson was at it. How is this any different from what Democrats have accused Republicans of for the last 4 years? Or is it suddenly okay when it is liberal dark money, a liberal dark money group, picking the nominees for the highest courts in the country? Mr. Chairman, again, I would like to have or seek unanimous consent to add the 2 shortlists from the Demand Justice website, and thank you.
Without objection, they will be added. Does the Senator have any further comment or questions?
No, sir, I'm clear.
Senator, I'm going to ask Judge Jackson if she'd like to reply to your your comment. It was not a question, and it'll be your decision. Judge Jackson.
Yes, thank you, Mr. Chairman. I've been a federal judge for 8 years, and I have a duty of independence. I clerked for 3 federal judges before I became a judge, and they were models of judicial independence. And what that has meant is that I know very well what my obligations are, what my duties are, not to rule with partisan advantage in mind, not to tailor or craft my decisions in order to try to gain influence or do anything of the sort. I have no control over what outside groups say about my rulings. I have no control over what reporters say about my rulings. And to some extent, all of my 560 opinions are written for people outside of the case. They're written for the public, they're written for the appeals court, and they're written for the parties. So my statement is that I've always been an independent judge, and I believe that that is one of the reasons why the president has honored me with this nomination.
Judge Jackson, I said from the onset that it was one of the factors, not all of them. I'm sure your jurisprudence weighed into it, but your response would read almost identically to dozens of judges who came before the judiciary, and they were rejected out of hand. The fact of the matter is, dark money is influencing it. Demand Justice is trying to expand the Supreme Court. So you can understand, after 4 years of hearing how the Federalist Society and other organizations were a dark money group with malign intentions, a group that is very much supporting you, why we would draw the same conclusion. Thank you, Mr. Chair.
Yes, I am. Thank you, Mr. Chairman.
Please proceed.
And I am so pleased that we have these two nominees in front of us today. And Judge Brown, I want to come to you first, if I may. I know you're fully aware that you are discussed regularly as a future Supreme Court nominee. Many of our Supreme Court nominees are, they come from the circuit that you would be serving on. But we do have some that are advocating to pack the court and expand the court. And I know that has been discussed. I think Senator Cornyn talked with you about it earlier. This is something I see as a dangerous proposal because it would basically set up a judicial arms race. If somebody adds, somebody else is going to add. And we know that it is said that even President Roosevelt's threat and unsuccessful attempt to pack the court was enough to intimidate justices. So first of all, do you believe that deliberately expanding the court to allow one president to pack it with their nominees would undermine confidence in our laws and undermine the separation of powers? And then secondly, if they were to expand the court, if President Biden did that, would you accept a Supreme Court nomination under those circumstances?
Thank you, Senator. I am currently a sitting judge in the lower courts, and as such, I am bound by Supreme Court precedent and by Supreme Court rulings, and I don't think that it's appropriate for me to comment on proposals about the structure of the court, about expanding the court, or anything of the sort, just as it wouldn't be appropriate for me to talk about or critique or comment on Supreme Court precedent. So I'm unable to answer your
But
question.
you are aware that groups that are advocating for you support that?
Senator,
You said
there are lots of people who have expressed their
All right.
support for me, and I'm gratified, but I'm really focused on this nomination, and I am hoping to be confirmed to the DC Circuit.
Okay. Ms. Jackson Akumi, I appreciate the comments that you've had to say about diversity. I always say that having a good input, having good relationships with individuals who are different from me and who have different points of view from me is something that is important to help me in public policy and to do a better job in representing all Tennesseans. So I appreciate the comments that you have made there. And I also noted, as I looked through your record, that you've represented many different clients during your tenure with the Federal Defender Program, and you've been a zealous advocate for those clients. I want to draw attention to a case where you defended a man who preyed on women for sex, trafficked, prostituted them. His victims accused him of physically restraining them with a firearm, despite believing all women. You called these women liars to cast doubt on their testimonies and claimed there was no evidence from the victims' testimonies and their words were dishonest. In your sentencing memorandum, you further shamed the victims' alleged prior prostitution work to support a more lenient sentence for your client. So do you support believing survivors of sexual violence and crime?
Thank you, Senator Blackburn. for the question. I'm not sure which case you are referring to. As we've shown, I've represented more than 400 clients, and a number of those cases were sex offense cases. What I can say is that calling a victim a liar is not something that I've done in court or in written record. It is certainly my job as an attorney to examine the evidence and present questions about the evidence to the court where appropriate and where necessary. And then,
Okay. Then let's do this. Let me give you the specific case and you can submit in writing, because your sentencing memo is something that does cause me concern. And we've been through a time where a previous Supreme Court Justice, Kavanaugh, during that, we've got an issue right now with Governor Cuomo, and whether knowing where you stand on that, I think, is really important. So I will get that to you in writing. Is that okay?
thank you, Senator.
Thank you. I appreciate that. Judge Jackson, I want to come back to you. In 2019, you granted a preliminary injunction against a DHS rule expanding the use of the department's statutory authority to use expedited removal procedures. The DC Circuit then reversed your injunction and found that Congress granted the DHS secretary sole and unreviewable discretion on expedited removal determination to enforce our immigration laws. Since the beginning of President Biden's term, the amount of illegal border crossings has skyrocketed, and it appears that we will exceed everything that we hit at that border in 2019. Last month, border agents took over 170,000 migrants into custody at the southern border, including 19,000 unaccompanied children. These border apprehensions have hit a 15-year high. The Biden administration's flawed immigration policy has only encouraged more and more migrants coming to the country illegally. On top of that, the administration is failing to properly handle the surge in illegal crossings and has allowed our country's borders to be overwhelmed. They have even failed to acknowledge the crisis exists. The administration's failures have caused massive suffering and endangered communities, and anyone who has not been to that border needs to go. I was astounded. So, Judge Jackson, do our Homeland Security officials lack sufficient authority to act decisively and timely to keep us safe and enforce these immigration laws?
Thank you, Senator. I've had a number of immigration cases, and in those cases, like the one you mentioned, what I'm doing is I'm evaluating the law, the immigration laws, very complex scheme, the facts in the particular case and the claims that are being made, the arguments of the parties. I'm not assessing the policy. I'm not making a determination about sort of in a general sense of whether or not DHS officials have enough authority or any other sort of policy consideration. Given what it is that I do and that is in my purview, I can't say whether they have enough authority. What I can tell you is that in the case that you referenced that I worked on, there was a disagreement. The DC Circuit disagreed with the way I had analyzed the statute, and that sometimes happens, that judges disagree on statutory interpretations, and so they made the ruling that they made, and that's binding precedent now in our circuit for how that statute is to be interpreted.
Okay. All right, I have one other I will submit to you for writing, and it has to do with the number of reversals that you've had. But I see Senator Booker there, and Mr. Chairman, I thank you for the time.
Thank you very much, Senator Blackburn. Senator Booker, are you available by remote? Thank you, Senator Booker. Senator Cruz.
Thank you, Mr. Chairman. Congratulations to both of the nominees. Judge Jackson, you and I attended law school together.
We did, Senator.
It is good to see you.
Good to see you again.
Congratulations. Let me start with a general question to both of you, which is, how would you define judicial activism?
I think judicial activism is when a judge is unable or unwilling to separate out their own personal views of a circumstance or a case, and they rule consistent with those views rather than the law as they're required to do.
I would give the same answer, Senator Cruz, and also add, although judicial activism means many things to many different people, for me it also suggests a judge who goes outside beyond the issues presented to the court. Judges are limited, they have quite a restrained role in that they are to only decide the issues presented to them, and one form of activism is going beyond that.
So what should a principal judge do if the law requires one outcome and your own personal, political, policy views are to the contrary? How does a judge resolve that conflict?
Oh, absolutely. The judge is duty-bound to follow the law. The law is the binding principle that guides a case, and judges need to methodically separate out their personal views. When I rule in my cases, I look at the facts, the law, and the parties' arguments in the same way in every case, and I methodically apply only those inputs because I'm trying very hard not to look at this case through anything other than the prism of the binding precedents of the Supreme Court and the DC Circuit. And so absolutely, there's no question that a judge has to set aside their personal views about how a case comes out and rule only consistent with the law.
That's absolutely correct, Senator. The roles of advocate and judge are completely different, but in the same way as an advocate that I set aside my personal opinions about my clients and what they were accused of or what they were guilty of, I would also set aside, if confirmed, my personal views, my personal convictions, if any, because the law is what guides and should guide judicial decision-making.
What are both of your views on the notion of a living constitution and whether we have a living constitution?
Senator, I have not had any cases that have required me to develop a view on constitutional interpretation of text in the way that the Supreme Court has to do and has to have thought about the tools of interpretation. I am aware that the Supreme Court, at least with respect to certain provisions of the Constitution that it has already interpreted, has looked at history and has focused on the original meaning of the text, say in the Second Amendment context in the Heller case. I just have not had any opportunity to do that. I have worked with those kinds of materials. When I was in private practice, I filed an amicus brief in which we argued using English common law about whether or not the English courts would have accepted evidence that had been extracted by torture.
So was this the amicus you did in the Boumediene case?
This was.
And was that pro bono representation?
That was. And I represented 20 former federal judges who wanted to make that point.
And what led you, look, with pro bono representation, that often reflects your own views. That's why frequently lawyers take it on. What led you to want to take that position?
Oh, I wasn't working alone. I was at a big law firm, and I was in their appellate division, and it was a client. It was a group of judges who I was assigned to work with as a part of my employment in the law firm.
But did you agree with the position you were advocating?
I was focused on my client's interest. I was doing what advocates do. I didn't have a personal view really of the issue other than just to make sure that I was making the most convincing argument that I could make on behalf of my clients.
So let me go back to the original question, which is, do you believe we have a living Constitution?
I believe that the Constitution is an enduring document. It is, it has, the Supreme Court has said, a fixed meaning, that we're to look to the original words in the Constitution and interpret, as lower court judges would interpret provisions the way in which the Supreme Court does, and they look at the text and look at the original meaning. And so if I ever had one of those cases, that is how I would approach the task.
Ms. Jackson-Akumi?
Senator, thank you for the question. I don't find these phrases particularly useful. As a lawyer, a living Constitution is very similar to me, like judicial activism. It means so many different things to many different people. I do know the Supreme Court has not used those terms. I know that Chief Justice Marshall said that we have a Constitution that was meant to endure for ages, which it has, and to be adapted to the various crises of human affairs. And I think that is what has happened with our Constitution over the years. And beyond that, it's the supreme law of the land. And if confirmed, I would be bound by the Supreme Court's interpretations of the Constitution. It would not be my job to make law.
So if you could both tell me your view of the importance of the First Amendment, and in particular the protections of free speech and religious liberty.
Well, Senator, my view comports with the Supreme Court's view, because as a judge, I have to apply the doctrines of the Supreme Court. And it is very clear from the court's recent rulings, from the recent COVID cases, Trinity Lutheran, Masterpiece Cake Shop, and various others, that the court is looking into and is concerned about restrictions on religious liberty as a First Amendment principle. As well they should be, because the First Amendment includes religious freedom as a core constitutional right. So my views comport with what the Supreme Court has held about these things, and I would have to apply the Supreme Court's principles in any of my cases.
Ms. Jackson-Akumi?
I agree, Senator Cruz. The First Amendment is fundamental. It's foundational. All of the freedoms protected therein: speech, press, assembly, petitioning for redress, and religion.
Thank you.
Thank you, Senator Cruz. Senator Padilla?
Thank you, Mr. Chair. Before I begin my questions, I want to take a moment to remark on the significance of this hearing. As Chairman Durbin reminded us and noted at the outset of this hearing, over the past 4 years, the prior administration appointed 226 judges.
I'm sorry to interrupt you, but my chairman's very strict on me, and I do want to get to ask the judge one question in my 35 seconds, and I'm sorry to interrupt you. Judge, you've been on the bench, and you've seen the federal judicial system up close, and I agree with you. America's a remarkable country. Do you think the federal judicial system is systemically racist?
Senator, thank you for that question. I am aware of social science research.
I'm sorry, I couldn't hear you.
I'm aware of social science research,
Yes, ma'am.
in particular in my former area of expertise, which is in sentencing, that relates to ways in which policy choices about various aspects of the system can have demographic disparate effects. The most obvious one is one that this body has worked on very hard and much appreciated, the 100-to-1 crack powder disparity. As a judge, I'm not looking at systemic effects. I'm not thinking about or focusing on or forming opinions about the research or the circumstances in the abstract like that. I am looking at each case. A person might make a claim that they've been discriminated against in a particular context, and I am applying the law to determine whether or not the law sustains that claim. So I don't really have a frame of reference to answer a question about systemic racism, but I am happy that you are thinking about those things because they're in the province of the policymakers like yourself.
Okay. Thank you, Mr. Chairman.